council get copies of the summary? Okay.
Defense is fine with your honor.
Case number 21 CR 74, State of Ohio versus Leah Johnson. President of the state is the assistant prosecuting attorney. President of the House President is attorney for the department trial. And are you Leah Johnson? Speak up.
Yes. Yes.
Okay. All right. Johnson's charged with aggravated possession of methamphetamine and 53 felony. She filed a motion for counsel for intervention in lieu of conviction. The court referred the matter for a report and evaluation. And I have received the report from the probation department, as well as material therein indicating that Ms. Johnson is currently in treatment at Another Chance Ministries, which is actually the former Freedom Associates. Another Chance purchased them earlier this year. Looking at here, I don't actually have a question. You have any?
I do, your honor.
Go ahead, my sign for
I have read your honor.
yes. All right, and Ms. Johnson, I have these stipulated questions that were signed. It looks like your attorney on the 22nd of June. Mr. King just signed them. You recall signing these?
Yes, I do.
And the answers to these questions are all accurate.
Yes.
Okay. And that will be filed with the motion. All right, I've been then presented with a plea of guilty, an entry granting intervention in lieu of conviction. And Ms. Johnson, this is a 4-page document, and it has your name, case number on it. And on page 3, there are signature lines, and at the top of the page, up here in the left-hand corner, there's a sentence that reads, "I enter this plea voluntarily," and immediately below that, there's a line with signature pen turned below. It looks like there's a signature of Leah Johnson. If that's your signature, I'm looking at.
Yes, sir.
When you sign this document,
June 22nd?
okay. And when you signed it, did you understand that part of this process is agreeing to plead guilty, meaning it's not a trial, and then we'll decide the issue of your intervention?
Yes, sir.
Okay. And is this something you still want to do?
Yes.
All right. And are you entering into this agreement voluntarily?
Yes, sir.
Now, I'm sure your attorney can explain this to you, but under the law, I'm required to put it on record and inquire of you to confirm it. Now, generally, when someone pleads guilty to a charge, the court finds them guilty, and then they are sentenced. And that can be community control or probation for up to 5 years. It could be a prison term. In this case, it would be 6 to 12 years, or actually, sorry, 6 to 18 months. 10 years, 6 to 18 months, and a fine of $5,000, as well as a license suspension 6 months to 5 years. Now, once the court imposes a sentence, wherever it is, then that means that that person has a felony conviction. Now, there's an exception to that for persons who meet the legal criteria, which it appears that you do, in cases in which their conduct was due to a an addiction or substance use disorder, and that was a contributing factor. And based on the report I have here, and the fact that you are in treatment, it appears that is the case. And if you are in a certified treatment program, which you are, then if you plead guilty, instead of finding you guilty, the court stays the proceedings. Stay is a word that means that basically it just stops, and we put it on an inactive status. And I accept your guilty plea, but I do not find you guilty. And I do not impose a sentence. Instead, I put you into an intervention program, which includes treatment and abstaining from use of substances illegally for at least a year, and also alcohol, by the way. And then also requires you to comply with conditions of supervision and probation department, which are less strict and less, there's fewer conditions for people in this program. And that can be for up to 5 years. I typically do it for 2, but it could be up to 5 years. And if you lead successfully your treatment plan, or if you're remaining compliant with it during that period, and if you comply with the conditions and pay off your court costs, then at that time, the court dismisses your case, and you are not a felon record. You have no felony record. Now, during that period of time, even though the record shows you've been indicted and that you pled guilty, you are still not convicted. And you still say to people, no, I am not a felon. I have suspended, but I am not a felon. And so this procedure offers you the opportunity to successfully complete and comply with these conditions and the treatment plan during that period. And then at the end of that time, the court dismisses the charge, even though you pled guilty. Then I always set it for a hearing to seal the record, and 99.9% of the time they're sealed, unless somebody does something in between those times that warranted being held over. And then the record is sealed, and then all the agencies and that have information about the case seal it, which means it's not open to inspection. They're not destroyed, but they're sealed. Because there are certain circumstances such as if you were charged again in the future, then both law enforcement and the probation department should look at it. So that'd be one exception. But the disadvantage to you is that if you are not successful, if you don't comply with the conditions of supervision, if you don't comply with your treatment plan, then there is a hearing to determine that, and you do have an attorney at that hearing. But if the outcome of that hearing is that you have failed to comply, then at that time you don't get to come back to court and start over. Then you're found guilty, and then the court has a sentencing hearing. So that's the gist of this, is an opportunity for you to, even though you pleaded guilty, admitting the crime, avoiding being convicted if you complete this program. You understand that?
I do.
Okay. Now, as charged, you have an aggravated possession of methamphetamine as a third-degree felony. And that is not eligible under the statute, but the agreement that's been presented is to amend the indictment to reduce it to attempted aggravated possession of methamphetamine. An attempt is under 292302 Vice Code, and it makes it a lesser included offense to any charge to, instead of commit the charge, to engage in conduct that is successful, resulted in the commission of that offense. And that reduces the charge by 1 degree. So by reducing this from a third-degree felony to a fourth-degree felony, it does make it eligible for this program. And the maximum prison term for that, as I said, is 18 months if one is imposed. Minimum 6 months if one is imposed. There's a maximum fine of $5,000 and a possible life suspension of 6 months to 5 years. So you understand that amended charge?
I do.
And you understand the possible penalties for the new amended charge?
Yes, sir.
Okay. Now, you're not facing any felony charges anywhere else, are you?
No, sir.
Okay. I know you weren't at the time this was completed, but sometimes things happen, so I always ask. All right. And you are not on probation, community control, parole, or post-release control for a felony.
No, sir.
Now, because this proposes a guilty plea, I have to give you the worst case scenario. So, if you were found guilty and sentenced to a prison term of 18 months, could be 6 to 18 months, depending upon the information submitted at the time. Should that happen, under the law, once that sentence is complete, the adult parole authority has the right to put you in what's called post-release control supervision for a period of up to 3 years. It's optional. It means they don't have to do it, but they could. But they make that decision. The judge has nothing to do with it. And if they do decide that you should be under post-release control supervision, then you're supervised by conditions that the APA sets by a parole officer. And then if they determine that you have failed to comply with those conditions, that even though you serve the entire term that was imposed by the court, they can return you to prison, make you serve an additional period of up to 9 months for one violation, which if you were sentenced to 18 months would be also be a maximum, because under the law, they can only require you to serve up to 1/2 of whatever prison term the judge imposed. But if you committed a felony when you're under post-release controlled supervision, then in addition to whatever sentence the judge in that case imposed upon you for that violation, the judge could also sentence you within this case for committing that offense while under post-release control. In this case, to an additional period of 1 year, whatever time's left on 3 years of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the case. You understand that? Now, even if you do not successfully complete the program, and if it is terminated, and you're found guilty and sentenced, the court's not required to sentence you to prison at that time. And then in that case, the court imposes what's called community control, which is a term that's used for probation now. And in that case, the court would put you under supervision by a probation department under conditions set by the court, which would be more extensive and more restrictive than the conditions for intervention. That could be for a period of up to 5 years. Now, again, if the probation department felt that you weren't compliant, they would have to file a written notice of that with the court, and there would be a hearing. You'd be entitled to have an attorney. And if the outcome of the hearing at that time wasn't you failed to comply, then the court would terminate you from probation control and then send you to prison for 6 to 18 months, as well as fining you the $5,000. Do you understand that?
I do, sir.
All right, now, the charge reads as filed in the indictment that on or about October 23, 2020, in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in an amount equal to or exceeding bulk amount less than 5 times bulk amount, violation of Section 2925.11 of the Revised Code. So that's the charge as a third-degree felony. But as amended, it would read then that on or about October 23, 2020, in this county, you engage in conduct knowingly and or purposely, which if successful would have constituted or resulted in that offense that I just read. So that then reduces it to attempt a fourth-degree felony. Now, you understand what it is you're charged with in that amended charge, with the state has said you've done it, how, when, and where you did it.
I do, sir.
And you discussed the nature of the charge, the evidence in the case, possible legal issues of the case, possible defenses you try to raise at trial, and possible outcomes of the trial with Mr. Armstrong.
I have.
And are you satisfied with his advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Are you taking any prescription drugs?
I do.
And what do you take it for?
I take cholesterol and blood pressure and gabapentin for neuropathy in my legs.
I've taken all those to understand. But none of those interfere with your ability to understand what's going on,
No, sir.
or to express your thoughts and understand the procedures.
No, sir.
All right. Now, you have certain constitutional rights. Oh, I'm sorry. I need to back up. Has anyone threatened you in any way to get you to plead guilty here today?
No, sir.
Now, other than being promised that if you enter plead guilty to count 1 as amended, that the state will recommend intervention, does anyone promise you anything other than that in case you plead guilty?
No, sir.
All right. Now, you have, do you hold any license or certification from any state agency from any kind of a profession or occupation?
No, sir.
Right. Now, you have certain constitutional rights that you must understand before I can accept this plea from you. First of all, you have the right to have counsel. I appointed Mr. Herman to represent you. And his appointment wasn't simply to work the case out, but to provide any defense to you that could be available under the law that you wish to provide. So if you decide you do not want to do this, that you want to defend against the case, then you will still have Mr. Armstrong to do that, and that would include having a trial if that's what you want. You understand that?
I did.
Right, now, under the Constitution, Mr. Johnson, you have a right to have a jury trial on this charge, which means 12 people would be selected from a group of citizens from this county that were summoned for jury duty on your trial. Now, after those 12 were selected, the evidence would be presented, and then they'd be instructed on the law. And that jury would have to decide on a unanimous verdict, all 12 would have to agree, as to whether or not to say prove the charge against you by proof beyond reasonable doubt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive writing, which means to give up your right to have a jury trial. And then in that case, you would have what's called a court or bench trial, meaning that the judge would be going to hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt by proof beyond reasonable doubt. You understand that?
I do, sir.
Right, under the Constitution, you have the right to confront the witnesses against you and cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, and your attorney, and anyone else is present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to try to bring out evidence intelligence to your side of the case. You understand that?
I do, sir.
Right now, under the Constitution, you have a right to use the power of this court to tell those witnesses to be in court to testify for you, just like the state. So if you have witnesses that you're not certain are going to come in voluntarily, then you file a request for a subpoena, and the court will issue that. That's a court order. And that subpoena forces those people that you've named in court to testify for you, even though they don't want to be here, which is the same way the state's witnesses are forced to come to court to testify against you. You understand that?
I did.
Under the Constitution, Ms. Johnson, you have a privilege against self-incrimination. What that means is that the witnesses what that means is that you cannot be compelled to give evidence or testify against yourself at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't. You decide. You decide not to testify. The fact that you did not testify cannot be used against you in any way, at any time, by anyone in the case. And the fact no one's even going to talk about it in the case, except in one situation, that is, if there's a jury trial and you don't testify, the judge instructs the jury that because that's your constitutional right, they cannot consider it for any purpose. You understand that?
I do.
Right now, under the Constitution, you have a privilege against self-incrimination. I'm sorry, you have a presumption of innocence. And what that means is that the burden of proof isn't on you to prove you're not guilty simply because you're going to die. The burden is on the state to prove that you are. In fact, under the law, you're not required to present any evidence in your defense in trial. You can, but you're not required to. Whether you do or not, the burden of proof remains upon the state of Ohio to prove your guilt by proof beyond reasonable doubt on every element of the offense charge as amended, which is the highest burden of proof that's known under the law. You understand that?
Okay.
Right now, originally, Ms. Johnson, you pled not guilty. Not guilty plea denies the allegation in the indictment denies you committed any crime. That plea waives or exercises all the rights that I've just described for you here this morning. Now, if you change your plea from not guilty to guilty, that is the opposite of not guilty plea. The guilty plea admits the allegations, admits that they're a crime as amended in the indictment, and that plea waives or gives up all the rights that I've described for you this morning except your right to have an attorney. You always have a right to have an attorney no matter what your plea. That exception, your plea guilty, waives gives up the right to have a jury or court trial. Waives gives up your right to confront witnesses against you and cross-examine through your attorney. Waives gives up your right to use the power of the court to compel force witnesses to come to court to testify for you, the same as the state. Waives gives up your privilege against self-incrimination because you're the one who says you're guilty, that's what's used to find you guilty. And waives gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced to being by the court if that was what was determined to happen. Now, it's not going to happen, but that could happen under the law. And finally, if wage goes up, your right to file an appeal. Any violation of your rights you feel could have happened, occurred, in this case, up until this point. Now, if I should sentence you the maximum sentence, or fail to issue an intervention, you could file an appeal. Any appeal would have to be filed within 30 days of your entry of sentencing being filed. Understand all that?
I do, sir.
And are you a U.S. citizen, Ms. Johnson?
Ma'am, sir.
Do you have any questions about the intervention in lieu of conviction plan or program or what may be required?
I don't.
Understand. Any questions about the charge, possible penalties, as a benefit?
No, sir.
You understand those?
Yes.
Have any questions about the plea agreement?
No.
You understand it?
Yes.
Any questions about the constitutional rights I've explained to you here this morning?
No, sir.
You understand those?
I did.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here this morning?
No, sir.
You understand?
I did.
Anything you'd like to speak to Mr. Herman about before we go any further?
No, sir.
Have any questions about anything I've explained to you today?
No, sir.
All right, then is it your decision, Mrs. Johnson, to withdraw your not guilty plea guilty to the amended charge of attempted aggravated possession of methamphetamine and fourth-degree felony as set forth in this written plea agreement that you signed and I've just gone over?
Yes, sir.
All right, then as to the charge, amended charge, in the indictment that would be that on or about October 23, 2020 in Huntington County, Ohio, you did knowingly and or purposely engage in conduct and successful would constitute or resulted in you having obtained, possessed, or used a Schedule II controlled substance with methamphetamine amounting to exceeding bulk amount less than 5 times bulk amount in violation of Section 2925.11 of the Ohio Revised Code as well as 29.3.02 the intent statute. A fourth-degree felony, very hostile, prison term between 6 and 18 months, fine of up to $5,000, and a hostile license suspension of 6 months to 5 years. How do you feel?
Guilty, sir.
Thank you. Be seated. All right. The court finds that the defendant was advised of all of her constitutional rights and made a knowing, intelligent, voluntary waiver of those rights pursuant to Criminal 11. Her guilty pleas accepted and ordered filed to the charge of attempted aggravated possession of methamphetamine as set forth in the plea agreement amending the original charge of third-degree felony down to fourth-degree felony. The court finds that the defendant's drug dependence and addiction was a factor to lead to the criminal activity for which she had been charged, and that rehabilitation through treatment will substantially reduce the likelihood of any additional future criminal activity. She has been accepted into an appropriate certified treatment program and is in the process in treatment through other chance ministries. She is otherwise eligible for controlled sanctions. She's not a repeat dangerous offender, and she's otherwise eligible for intervention under the criteria set forth in the statute as evidenced by the stipulated questions as well as her admission into the treatment program. The court will note from the report that her only prior convictions are speeding tickets, and there were another charge back in the time of this offense, I guess, was dismissed, so it's her first criminal offense. And therefore, the court will stay all those proceedings in the matter, and although the guilty plea is filed, we don't find him guilty this time. It's ordered the court to defend be placed under community control supervision under the intervention of conviction program as previously approved by the court. And we'll go over those with you so that they are to get a copy and sign it. And you'll be required to comply with those conditions. You're required to successfully complete your intervention plan, or at least be compliant with it, for a period of 2 years. This will be for 2 years. And also required within that is a statutory requirement that you may not consume any drugs other than those for which you have a lawful prescription, which you must provide a copy of to the probation department periodically, or alcohol. And even though alcohol is not involved in your offense, treatment community and my experience courts judges understand that people that are using drugs illegally, if they quit using those, oftentimes they'll turn to other types of medication. And alcohol is another way to self-medicate. And so that's why you're not permitted to do that, so it doesn't interfere with recovery. You'll be required to comply, again, with all those conditions, which will include, random drug testing, and other conditions that will work with you. You'll also be required to pay court costs, and to pay for any programming that they may have you go through. Now, in the event that you successfully complete this plan, and the court will then dismiss the charges against you and set the matter for sealing hearing, and if there's nothing that happens from that time in the hearing is sealed, then the records will be sealed and removed from the public domain. Now, if it's alleged that you have failed to comply, then the probation department will have to file a written notice that the court will be served a copy of that. You will have a hearing, you will have an attorney at that hearing, and if the outcome of that hearing is that you have failed to comply with either your treatment plan or the conditions of supervision, or both, then at that time, the court can terminate you from the intervention program, find you guilty, and then proceed with the sentencing hearing, which would indicated result in a sentence of between 6 and 18 months, $5,000, and a license suspension of 6 months to 5 years. All right, and the investigating officer has been notified of this disposition of the agreement, Mr. Okay.
Yes, sir.
All right, so this completes your case, Ms. Johnson. And again, like I said, even if you plead guilty, you don't have a felony conviction while you're in this program. So we need to report to probation department immediately after court. You'll no longer be under the pretrial supervision provision, house arrest and all that. That's all lifted. They will go over your new conditions with you, and again, you'll get a copy of it and you'll sign it. And those will be the conditions you'll operate under. You may have a different officer supervising you. I'm not sure. Charge even does some of these, some others I think Ms. Kelly assists with. But that will be the situation now. All right, anything further, counsel?
There.
All right, good luck.